The president is Attorney Alexis Spencer, representing the plaintiff, Mother Catherine Lynch-Kuso. Ms. Lynch-Kuso is present with Ms. Spencer. In addition, Attorney Christina Hills is present, representing the defendant, Father Jeremiah Kuso Sr. Mr. Kuso is present. Good morning, everyone.
Morning, Your Honor.
Please have conferred with Ms. Brower this morning from the front of the court, who has provided the court the following recommendation that mother's supervised parenting time will be switched to supervised therapeutic visitation parenting time when available at the recommendation of Family Counseling Shelter Services. Neither mom nor maid shall have electronics during those visits. The first family therapy session is scheduled for this evening. That is separate from Family Counseling Shelter Services. Presumably that is with another agency. Is that correct? Ms. Spencer, Ms. Hills?
The same agency, Your Honor.
Same agency.
Yes.
Okay. So the family therapy, that involves both parents and Megan?
Initially, I believe it will just involve mom and Megan, and I believe both parties would follow the recommendations of the family therapist.
Okay. It's further recommended that defendant Father Jeremiah pay the co-pay for the first 20 individual therapy visits for Megan. After 20 visits, parties shall share the co-pays 50-50. The parties shall notify each other of the health issues that the minor children have during their parenting time through app close, and all appointments for the children should be added to app close at the time the appointment is scheduled. Place motions for show cause at this point will be dismissed, and the listing price of the camper shall be reduced to the loan payoff amount to facilitate that sale. That is the recommendation. Ms. Spencer, is this recommendation good with your client this morning?
Yes, it is, Your Honor, and we would just additionally be requesting a review date 3 months out.
Would you agree, Ms. Hills?
That's fine, Your Honor. And we had understood that the dismissal of the show cause motion would be with prejudice.
Ms. Spencer?
Yes, we did agree on that.
Okay, right. So you want a date? We'll give you a review date, certainly. Ms. Hills, is this recommendation good with your client this morning?
It is, Your Honor, with the understanding that the show cause is dismissed with prejudice.
Okay, Ms. Brown, perhaps you can add that language that's dismissed. Oh, I'm sorry, it does say that. The show cause is dismissed with prejudice. So I neglected to say that. That is in written form. Thank you, Ms. Brower. About any time.
I'm sorry, I'll be out of the country the first 2 weeks of October. The 5th,
Okay.
actually, I'm here the 3rd and the 4th if the court wanted to squeeze us. Actually, I'll be here the 1st and the 2nd as well. But
We
after
have
that, I'm off 2 weeks.
Okay, the morning of October 2nd, we have available.
I can do that.
I could do any time on the 2nd after 9:30.
After 9:30 or what, 9:30 or 10?
I could do 10. That would be better.
All right, great. Ms. Brown, if you could add just a sentence to the end, the court will review parenting time. You know, specifically indicate parenting. That's the issue, is reviewing parenting time, correct?
Correct.
Yes, Your Honor.
On October 2nd, that's a Wednesday, 2024 at 10 a.m. via Zoom. All right, Ms. Spencer, Ms. Hills, do either of you want to voir dire your respective clients regarding this recommendation this morning?
No, thank you.
No, Your Honor. Thank you.
All right, the court would like to thank Ms. Brower, as well, of course, Attorneys Hills and Spencer helping facilitate this resolution at this point in time. Megan's going to be 18 soon, correct?
Correct.
Yes, Your Honor. About 5 months.
Okay, this fall. Obviously, it's important, and obviously, Mr. Kuso, your assistance is in your daughter's best interest to help facilitate that, encourage it, say kind words. I mean, Megan needs to have a mom in her life. So to the extent that you can help facilitate that, that will benefit your daughter. So forward with that, the court will adopt the recommendation. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
All right. Thanks, Your Honor. You too.
For the record, this matter is before the court for the purpose of reviewing parenting time. I believe specifically mother's parenting time, as well as plaintiff's motion to prohibit unsupervised contact between the minor child and the maternal grandmother. This hearing is being conducted via Zoom. Present is Attorney Alexis Stang, representing the plaintiff mother, Catherine Kuso. Ms. Kuso is present. In addition, Attorney Christina Hills is present, representing defendant father Jeremiah Kuso Sr., who's also present. Good morning, everyone.
Good morning.
The parties have conferred this morning. with Mr. Barr from the front of the court is provide the court with the following recommendation. Mother shall have therapeutic visitation with Megan on alternating weeks. On opposite weeks, mother shall have counseling sessions with Megan. Both of those sessions shall take place at Family Counseling Shelter Services. Plaintiff's motion regarding prohibiting unsupervised contact with the maternal grandmother, it's recommended that be denied. Further, that the parties shall share and split 50-50 any necessary extracurricular expenses if the parties agree to an extracurricular activity for the children. Finally, that the party shall respond to close messages from the other party regarding the children within 48 hours. The only thing that this does not address, what about the list? Has the camper been sold? Ms. Hills?
I have not been updated as to the camper sale. Frankly, that fell off the radar with the discussion of the extensive discussion of the minor children today.
Okay.
I believe the price.
Last order of July 10th, that was another issue, was the defendant was to reduce the list price of the camper, reduce it to the loan payoff amount. So I'd like to address that today.
That was done, Your Honor.
Okay, the camper has been sold?
No, I don't believe it's been sold. The listing price has been reduced though by half, and it has been reposted on all of the sale sites.
Okay. Have there been any offers received?
No offers. I did have interest. People were interested, but nothing concrete.
Okay. And then you have to refresh courts, remember who's making the payments in the interim?
She is
My
making the
client
payments.
is.
And
those
the
are-
insurance, and my client is a named insured on the policy. He can request proof of that really at any time, again, for her to show that that's the case. I'm not aware of any missed payments. Are you, Jeremiah?
No, not yet.
So Ms. Kuzno is handling the marketing of this camper, is that correct?
She is.
Yes.
It's fully her responsibility.
And it's a joint financial debt, is that correct?
Yes.
It is.
Right. All right, so it's going into winter, Ms. Kuzno may want to reduce that, but I'm not sure if there's a deficiency, how that's going to be addressed. I don't know if it was addressed in a prior order.
That would be mom's responsibility completely. She's taken on sole responsibility financially for this camper.
Okay. Should we address that in this order, that just simply noting that the camper continues to be marketed by the plaintiff?
I'm fine with that, Judge. Thank you for catching that.
Right, so Ms. Bruff, you just add to this that the plaintiff shall continue to market the camper
Your Honor.
for sale. All right, with respect to the balance of the recommendation, Ms. Stangs, this recommendation agree with your client?
Yes. Thank you, Your Honor.
Right, Ms. Hills, this is a recommendation agree with your client?
Yes, Your Honor.
Right, both parties did confer, were involved in the discussions with Ms. Brower this morning. Do you want to voir dire your respective clients regarding the recommendation this morning, Ms. Stang or Ms. Hills?
No, thank you.
No, thank you, Your Honor.
And obviously, parenting time will continue with respect to the Mackenzie and Natalie as previously ordered. Is that correct?
Yes.
Yes.
Okay. The court just, even though this recommendation addresses primarily Megan, we do have two other children. The court's aware of that. So we do not need a future review date. Is that correct? If there's an issue, someone can petition the court.
That's
That's
correct.
correct, Your Honor. And Megan is turning 18 in early December as well. So she'll be aging out as far as the court's jurisdiction. Hopefully, Mom and Megan can continue to try to mend that relationship after she's 18, but it would be without court supervision at that point.
Okay. All right. Thank you, Ms. Brower, for assistance. Court will adopt the recommendation with the addition that the plaintiff will continue to market the sale of the camper. All right. That will conclude this matter. We can zoom out after the rest of the day.
Thank you, Your
Thank
Honor.
Welcome. For the record, this matter is before the court on the plaintiff's motion to modify parenting time and the supervisor for parenting time. This hearing is being conducted via Zoom. President Attorney Eugene Ferguson representing the plaintiff. Moving party Cody DeFalco. Mr. DeFalco is also present. Good morning, Mr. DeFalco. Can you remove your hat during court, please?
Yes.
Thank you. Also present is Attorney Christopher Fleming, representing the defendant mother, Lauren DeMille. Ms. DeMille, previously present with Mr. Fleming. Good morning, Mr. Fleming and Mr. Ferguson.
Hey, good morning, Your Honor.
It's been a while, Mr. Fleming, since the court has seen you. You've been busy over in Lenawee County, but you're back in Monroe County. That's good to
Absolutely.
see
Back
you.
in private practice, Judge.
The parties have conferred this morning with Mr. Pratt for the front of the court, who's provided the court with a fine recommendation that the defendant, mother, shall continue to have supervised parenting time every other Saturday from noon to 5 p.m. The supervisor shall remain Lynn DeMille, which I believe is the maternal grandmother.
Yes, Your Honor.
And it's further recommended that court order that there be no use of marijuana before or during parenting time. And obviously by either party. That's the recommendation. Mr. Ferguson, is this recommendation agree with your client this morning?
No, Your Honor, we would object to it.
Okay. Your objection?
The objection is basically this, that we have the current situation where my client has a full legal and physical custody of the child. We agreed previously that the defendant's mother would be the supervisor. However, what happened was one time when my client was having the supervised parenting time.
Yeah, but Mr. Ferguson, the court did read all the pleadings. I'm totally for the allegation. Your objection is to the parent time schedule or the supervisor?
The supervisor.
Okay, so you're fine. Your client is fine with the alternating Saturdays from noon to 5. What supervisor, and the court's aware there was an issue between defendant mother and the maternal grandmother, apparently in the presence of the 5-year-old child. Who do you propose as a supervisor?
We suppose either that there be a third party, or we would prefer that the plaintiff be the supervisor.
Well, correct. It's obviously a third party. Who do you recommend that the child knows?
I don't know that we have anyone that the child knows that we could.
You got to propose an alternative to the court.
I'm sorry, Your Honor.
You need to propose an alternative to the court. There was one incident where there was an alleged altercation between the defendant mother and the maternal grandmother. Is that correct?
Well, basically what happened is after he saw it, he was there, and then she would frequently leave, she being the defendant, leave, and we believe that she was continuing to use marijuana because she would always leave and go to her car and say that she was nervous and had a situation she had to deal with. So we believe she continued to use marijuana. She just didn't do it in his presence. And she also fought with him over using marijuana as if it was acceptable.
Well, I would think that Mr. DeFalco could observe Ms. DeMille when he drops off the child, and they exchange the child to determine if she in fact appears to be under the influence. And if so, he doesn't turn over the child. And likewise, when he comes home, if he smells marijuana and then believes that she's under the influence, that's when he should address it. I don't know how else the court can monitor that marijuana use, other than if in fact he should confront her if he believes that she's using marijuana. But is the grandmother using marijuana as well?
Not to my knowledge. I don't think we're not alleging the grandmother uses it, but she allows it. She allowed it the day he saw it.
And I don't know, other than having a law enforcement officer, I don't know who else, but we just want to make sure that, it's a legitimate concern, but grandmother is there, maternal grandmother is there all the time. Correct? It's just that you believe your objection is that the maternal grandmother allows mother to use marijuana during the parenting time. Is that your primary objection?
That's our objection, and my client saw that. He saw her allowing her to use.
All right. And again, but your client, who does your client propose? I mean, there's got to be, unless he wants to be unsupervised. I mean, obviously, there's a legitimate reason to be supervised. That was previously ordered back in September of 2023, because mother was dealing with a substance abuse issue. So unless there's an alternative.
I mean, he'd like to be the supervisor.
Okay.
He'd like to be there.
Okay.
He'd like to be there to make sure that there's not an issue. I mean, this woman has a significant issue with substance abuse.
Okay. All right, Mr. Fleming, response?
Thank you, Judge. There has been no basis to file this motion. The plaintiff only filed this after finding out that he wasn't allowed to be there during mother's parenting time to supervise. So he filed this motion after a friend of the court told him that grandma could supervise. That's why this motion was filed.
Right, Mr. Fleming, does your client deny use of marijuana during parenting time?
She does, Judge.
Okay. I guess we could produce a maternal grandmother and have her provide some sworn testimony. You can speak to her, Mr. Ferguson. We can set a hearing date. You can have a maternal grandmother. Is she readily available? Can someone call her this morning? Have her Zoom in?
I actually have her in my office, Judge.
Okay, why don't you have her come on in?
Absolutely. Here, I'll have her.
Have her come in. And all right,
Morning.
ma'am, can you have a seat, please?
Good morning, Your Honor.
Good morning. Can you please state your name for the record, please?
Lynn Rising DeMille.
Relationship with Lauren.
Pardon me?
What is your relationship with Lauren DeMille?
I am her mother.
All right, please raise your right hand to be sworn, please. Do you solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Mr. Ferguson, you want to examine maternal grandmother?
Yes. You have been the supervisor of the minor child for your daughter, correct?
Correct.
And are you aware that in the past your daughter Lauren has abused drugs and alcohol?
I'm aware of her past, yes.
Okay. When's the last time you observed her using marijuana?
January of this year, the one time that she did it in front of Cody. I didn't know she had the pen in her pocket and she pulled it out. And I don't know why, but I didn't know she had it. So since then, I haven't seen any.
You did see it in January of 2020.
One time, yes.
Okay. And after that, did Cody start staying for parenting time for some time period?
He had always been staying for parenting time up until a few months ago. We always had to meet him somewhere and he was there and he was always there.
Okay. Well, after January, I believe it was January 20th, 2024, when rolled out the marijuana pen. Is that correct?
Yes, correct.
Okay. Had you seen that marijuana pen before?
Not in front of me, no. I mean, I knew she probably had one, but I hadn't seen it.
Okay. So do you know during that time period how often she was using the marijuana pen?
Not unless she was sitting in front of me. I didn't know when she was using it. No. If she was up in her room or outside, I didn't.
Yeah. Are you aware of when she buys refills for this marijuana pen?
Yeah, but I haven't seen her buy anything in quite a while.
Okay. So you were previously aware that she was using the marijuana pen?
Yeah, previously, yes, I was.
And how often was she using it?
I don't know. I mean, maybe daily at one time, but not lately.
When was she using it daily to your knowledge?
Back in January and February.
And what makes you think she stopped using it?
Because she hasn't been able to buy any.
Why is she not been able to buy any?
Lack of funds.
And how do you know that?
Because I know she doesn't have the money.
Did you have more money in January and February?
Apparently, but I just haven't seen her buy any lately.
Okay, but why do you say
she can't drive anywhere? I have to take her, so.
What's different about her financial condition now as opposed to January, February 2024?
Well, actually, it's no different other than she hasn't received her payment this month from her insurance company.
Okay. So during the parenting time when Cody's been there, have there been times when your daughter leaves?
I suppose she may have, but I don't specifically remember.
You don't recall any times when she says, I have to go for a little while, and she goes to her car or goes somewhere else?
If she did, I honestly don't remember that happening. Whenever we were with him or at Get Air or wherever we were meeting him, she pretty much was there the whole time. And then we'd leave and go wherever they were going. They'd go eat lunch. I don't remember her specifically leaving an awful lot, no.
On January 20th of 2024, do you know how often your daughter was using marijuana?
At that particular day, apparently that day and maybe a few days around it, I don't know. I don't watch her when she's with me 24/7.
Okay. Did you ever see her during that time period and she appeared to be under the influence of marijuana?
I don't know how to determine when a person's under the influence, but I suppose, yes, I might have seen her, yes, at that time.
So you're saying you don't know what a person acts like when they're under the influence of marijuana?
Well, sometimes they're a little different, but she just, I mean, but I didn't see her acting out at all or acting high at all. And like I said, she's in her room. I don't see what she does up in her room. I don't monitor her when she's up there. I monitored her when she was with Everett. And that time we were with Everett and Cody. And ever since that time, anytime we've been with him, I'm right there and I don't see her doing anything.
Okay. To your knowledge, is she using any drugs right now?
No.
Is she under any prescribed drugs?
Well, she has her prescribed drugs that she takes, yes.
And what are those drugs?
Objection, Your Honor, relevance.
I mean, it's relevant if she's under the influence of a drug during and not during parenting time.
This just appears to be a goose chase at this point, Your Honor. I don't see how this would be relevant. It's not even in their motion or anything like that. And
I mean, again, I think it's relevant if she's using drugs that affect her ability to watch the child. I don't know what could be more relevant than that.
and she'd be supervised at that point, so it'd be irrelevant.
So you're talking about prescribed medications, Mr. Ferguson?
Yes, I'm just asking if she knows if she's on any prescribed medications. If she does, yes. If she doesn't, that's fine as well.
All right. The court give her some leeway. Ma'am, do you know if your daughter's takes any prescribed medications?
She takes medications prescribed by her psychiatrist, yes.
Okay.
And what are those medications?
Buspar, fluoxetine, Prozac, and her Vyvanse.
Okay. And how do those, in your observation, affect her behavior?
How do they what?
How do they affect her behavior after she takes those drugs?
Well, at this point in time, she's been taking them for so long, there's not a gross change. The idea of the Buspar and the fluoxetine are to help with her OCD and her ADHD.
Okay. I have no further questions. Thank you very much.
All right, ma'am. What was your response when you observed your daughter smoking marijuana in the presence of Everett back in January of 2024?
I didn't know she had it on her, and I was.
Understand. Once you determined she had a vape pen or a marijuana pen on her and saw her pull it out in front of Everett, what was your response?
I was in the kitchen with Cody, and then I told her I asked her what the hell she thought she was doing.
Okay, what was your response? Did you say that's just curious what you're doing? Go ahead.
No, I don't.
Go ahead and do it.
I don't want her smoking it. I don't like it.
Did you tell her to put it away and not do that in the presence of a child? That's what the court's question. I'm not telling you your answer. What was your response, ma'am?
I honestly, back in January, can't remember if I told her to stop. I'm sure I probably insinuated as much. And I told Cody, I'm sorry, I didn't know she had it. But I told her before not to do it.
Okay. So have you observed that since January of 2024?
In front of Everett? No.
Okay. And if you observe it in front of Everett, what would your response be, ma'am?
Well,
as grandmother?
I would want her not to do it, and I would take it away from her.
Okay. All right. When Everett has plenty of time with your daughter, do you ever leave the home?
No.
Okay. You're there the entire time between noon and 5 p.m. Is that correct?
Yes.
And do you understand that you can't leave and go to the grocery shop? You need to be there as a constant supervisor from noon to 5.
If I leave, I take Everett and Lauren with me. But no, I never leave. Right. I'm always there.
Okay, that's the primary concern. Mr. Fleming, is your client still on probation?
She is, Judge, and I believe she is being drug tested under that regimen as well.
Okay, Miss Lauren, is that correct? You're still on probation in Lenawee County?
I'm sorry, go ahead. What was it, Your Honor?
Miss Lauren, are you still on probation in Lenawee County?
No.
Okay, I thought you were on probation for 3 years from and after February 2024.
That's in Ohio.
Okay, are you on probation in any state in this country?
Yes.
Okay, in the state of Ohio. And when does that probation, what's the term of the probation?
3 years, and I assume it started, if I remember right, it started back in February, as the date you said.
I'm sorry, 3 years starting when?
It was back in February, the date that you. had
Twenty twenty-four.
Yes,
How often do you meet with your probation officer?
I talk to her monthly, and actually next month I see her. I'm actually seeing her next month.
Are you required to submit to random drug screens?
I do breathalyzer, or I'm at the random breathalyzers. I actually am not. I have to do all random drug screens or anything.
Are you required to submit to random drug screens, Miss Lauren?
No.
Okay. Are you, does your order of probation prohibit you from using any unprescribed medications like marijuana?
I believe, I believe so. Yes, I'd have to look over the conditions, but my conditions are related to alcoholism, and I have random breathalyzers whenever they feel they need necessary or anything like that.
So your orders of probation do not prohibit use of marijuana. Is that what you're saying?
I'd have to look at the actual order.
I'm sorry?
I would have to look at the actual order, Your Honor.
You don't know? So as far as you're concerned, you can use marijuana during while you're on probation. Is that correct?
Ideally, no. If you can't drink, then you should be able to. All I know is that my thing, that because I don't do random drug tests, I know my things say breathalyzers and everything like that.
Do you understand you cannot be under the influence of anything when this minor child is in your possession with a mother?
100%.
Do you understand you cannot use marijuana prior to, you can't be using marijuana Saturday morning before everyone comes over?
Yes, Your Honor.
If it comes to the court's attention that there's some evidence that you're doing that, the court's going to suspend your parenting time, ma'am. Right. Anything further, Mr. Ferguson or Mr. Fleming?
I would indicate that it's clear when the grandmother is testifying, she doesn't know whether Lauren, the defendant, is using marijuana or not. She's not really monitoring that. It seems clear to me that she probably is using marijuana from all the testimony here. And I think the safest thing for this child is to have my client present during the parenting time. The grandmother is not really watching her. She's admitting that she's used marijuana.
Mr. Fleming, any objection? I'm sorry, Mr. First, I have a very busy docket this morning. Any objection to dad being present if he chooses to do so?
I would. I think there should be parenting time with the mother, and her mom can supervise, and she's an
There were statements that Mr. DeFalco has been present during past parenting time. So apparently there's been no objection to that in the past.
I wasn't worried that I thought you had to be there.
We thought that, well, previously my client believed that was to the court order that he had to be present. When they found out that he wasn't required to be present, that's when this motion was filed to change the supervisor judge. But we would object to him being present during the parenting time. I believe that would interfere with Ms. DeMille getting to know the child again at this point, Judge.
All right. The court believes that the maternal grandmother that will provide a level of appropriate supervision and protection for this minor child. The child is 5 years old. There's no evidence that the child has been jeopardized. And hopefully that Ms. DeMille will comply with this court's order and be an effective mother. You can't be an effective mother when you're high, Ms. DeMille. And grandmother, you should make sure that your daughter's properly spending time with her child. And not be, she shouldn't be up in a room. If she's up in a room for an hour, there's something going on that she doesn't want you to know about. So grandmother, be attentive. If it comes to the court's attention that you're not being attentive, and there's any issue with this child, the court will in fact suspend parenting time. But at this point in time, the court will adopt the recommendation of Ms. LaPrade. Parenting time will continue, alternating Saturdays, noon to 5. Supervisor shall continue to be the maternal grandmother, Linda Mill, and no marijuana use prior to or during parenting time.
Hey Judge Braunlich.
Yes.
I might be starting a new job here very soon. The parenting time might have to be adjusted by a couple hours.
Hey, we're talking. Do you want to talk about that this morning? I've got another case I need to move to that should have been raised earlier this morning. If this parenting time,
I just applied and I just got an interview, but just 10 to 3 because I drive nights. I'm a truck driver, and yeah.
All right, I'll talk with Mr. Pratt. Put you back in the breakout room. We can talk about if you need to change the time of this parenting time.
Okay.
Wasn't where that was an issue. Mr. Pratt, are you still available?
Yes, sir. That was not raised in the breakout room, but we can go discuss it.
Should have been. All right, put you back in the breakout room and talk about whether you need to change the times. It should not be a problem on Saturdays. I'm sorry, Sundays. He wants Saturdays. If he wants 10 to 3.
Yes.
So you got 4 hours. Any objection to that, Mr. Fleming? Just to change the time from 10 to 3 rather than noon to 5?
You said, I don't know yet. I have to think about it. Like, and
Can we go with Ms. LeBrad real quick, Judge?
Yep, get breakout room. Okay.
Thank you, Judge.
Thank you.
First motion was an emergency motion. You want an ex parte? I'm like, really? Is that really an emergency? Of course, I denied it, but that was an emergency motion. Objection to a referee recommended order that a bench warrant issued due to defendant's failure to pay child support. This hearing is being conducted via Zoom. President is Attorney Timothy Churchill representing the defendant, John McArter. Is Mr. McArter present on audio?
Yes, I am.
All right, good morning, Mr. McArter. Also present is Attorney Maria Zgorski representing Catherine McArter. Ms. McArter, is she present this morning?
She is not. Judge, I don't think this was on her radar because it's really, we don't really have much to say about the process at this point.
Very well. Also present this morning is Monroe County Front of the Court Attorney Rebecca Hicks. For the record, Ms. Hicks has provided the court with fine recommendation that referee recommended order be rescinded and canceled, making reference to an enforcement order dated July 10th, 2024. I believe that's the primary concern. Mr. McCarty did not want the bench warrant to issue. Hopefully get back on track. Is this recommendation agreeable with your client this morning, Mr. Churchill?
Yes, it is, Your Honor.
All right, Ms. Gorski, any objection?
No, thank you.
All right. I'm not sure exactly what the July 10th enforcement order references, but obviously, Mr. McCarty, you need to get on top of these rearages. Been the court's experience when you get rearages in excess of $10,000, the state attorney general looks at it's on the state attorney general's radar for authorizing charges of a felony non-support. So you want to get these rearages, not get them under $10,000 as soon as possible, so it's avoid possible criminal felony charge. With that, anything further this morning, Mr. Churchill, or Ms. Gorski, or Ms. Hicks?
Your Honor, just that enforcement order is in your FOC motions orders queue. It does adjourn his show cause onto my docket for July 30th with some requirements for him to make some payments prior to that date.
Okay. And Mr. Churchill, Mr. McCarty is well aware of those conditions. Is that correct?
Yes, we are, Your Honor. Yes.
All right. Okay. If there's nothing further now, the court will adopt those orders and recommendations, and that will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
This matter is before the court on the plaintiff's motion for parenting time. This hearing is being conducted via Zoom. President Attorney Ronald Bruce representing the plaintiff's father, Timmy Goins. Mr. Goins appears to be present with Mr. Bruce. In addition, Attorney Alex Goldman is present representing defendant mother, Devin Goins, and Ms. Goins is present. Good afternoon, everyone.
Good afternoon, Your Honor.
The court has received the following recommendation that father shall have supervised parenting time Saturdays at noon until 5 p.m. at his home, supervised by his mother, the paternal grandmother, and plaintiff's mother shall transport the children. So the paternal grandmother will transport and supervise dad's parenting time every Sunday. I'm sorry, Saturdays, Saturdays, noon to 5. Further, the parties shall mediate with Mr. Walker on September 4th at 1:30 p.m. via Zoom and subsequently appear before this court for a continued pretrial conference. The court would also note this matter is scheduled for pretrial today, so the court wanted to move the matter forward to mediation. Payment to this recommendation on interim basis is Mr. Bruce, does this agree with your client?
Yes, Judge.
All right, Mr. Goldman.
Yes, Your Honor.
In anticipation of the mediation on September 4th, the court will leave discovery open. Is there real estate to be divided, Mr. Bruce?
No, Judge.
Parties separated in March, so we have some personal property to divide. Is that correct?
Yes.
Okay, so I'll note that perhaps parenting time will be an issue. The court always likes to assume the parties can share joint legal custody and make jointly any major decision concerning the welfare of the children. We don't need to bog down on physical therapy, but the court would hope that we can start with joint legal. And so the primary issue will be that of parenting time, personal property division. Is there significant unsecured debt, Mr. Bruce?
No, Judge.
Credit card debt. Do the parties have any retirement benefits to be divided?
I got a 401k.
401k, my client, Judge.
There's like $4,000 in it.
Okay. All right, so Mr. Goldman, would you agree that the issues are parenting time, real property division, and division of pension benefits?
Yes, Your Honor.
All right, Mr. Bruce, Mr. Goldman, would either of you like to voir dire your respective clients regarding this recommendation?
No, Judge. I don't feel the need to, Your Honor.
Very well. So we'd like to thank Ms. Brower for her assistance. Please move on. We should have a discovery fully completed by September 4th. So the party shall meet with Mr. Walker on September 4th, 1:30, subsequently appear before this court for a continued pretrial conference. With that, the court will adopt the recommendation, and that will conclude this hearing. Thank you, Mr. Goldman and Mr. Bruce. We're going to zoom out. Have a good rest of the day.
Thank you, Judge. Thank you, Your Honor.
Thank you. For the record, this matter is before the court for continued pretrial conference. Subsequent, the parties have engaged in mediation with Mr. Walker from the front of the court this afternoon. This hearing is being conducted via Zoom. Present is Attorney Ron Bruce, representing the plaintiff, Timmy Goins II. Mr. Goins appears to be present. In addition, Attorney Alex Goldman is present, representing the defendant, Devin Marie Goins, and Ms. Goins is also present. Good afternoon, everyone.
Good afternoon, Your Honor.
Been able to make progress toward reaching their own resolution this afternoon, Mr. Bruce?
Yes, Judge, you think the parties have an agreement?
I'm saying as well, Mr. Goldman?
Yes, Your Honor.
Wonderful. Who would like to place that agreement on the record?
I can, Judge.
Please, Mr. Bruce.
Judge, the parties have 3 minor children. Parties will share joint legal custody. Physical custody is not being addressed in the final judgment. Child support will be $1,376 a month, commencing on 9/1/24. Medical, out-of-pocket medical will be split 66% to my client, 34% to Mrs. Goins. Parenting time will continue per the current order, with my client receiving supervised parenting time, I believe 12 to 5 on Saturdays. Parties will schedule a review approximately 30 days out to review my client's parenting time. Parties agree that during their respective parenting time that they will administer any prescribed medication, basically follow whatever prescriptions the minor children have. Spousal support will be in the amount of $584 to Mrs. Goins from my client for a period of 36 months. Parties have no real estate. Personal property has pretty much already been divided. The only items that my client is seeking to have returned is a collection of books that he has and a locksmith set that he inherited from his grandfather. Retirement, my client does have a 401k. Mrs. Goins will receive the marital portion of that. It's my understanding that Mrs. Goins can procure a quadro at no expense, so she will prepare that paperwork. Parties share one bank account with Directions Credit Union. Parties will cooperate to remove my client from that account. Mrs. Goins would be awarded any of the proceeds in it. Life insurance, each party will keep their own. There is no joint debt. In regards to tax benefits involving the minor children, I don't believe Mrs. Goins is currently working, so my client will claim all 3 children for 2024. Going forward in 2025, the parties will split the benefits for the 3 children. Mrs. Goins will claim 2 of the children in 25. My client will claim 1. They will alternate the 2 and 1 every year until there's only 1 child, at which point Mrs. Goins will claim that child. In regards to the maiden name, Mrs. Goins would like the option to change her name back to Ridner, Ridner, R-I-D-N-E-R, at her desire. So she'll just have the option to make that change. And I believe that's everything.
Mr. Bruce, so the spousal support, is that non-modifiable in terms of amount and duration, namely the $584 per month for 36 months?
Yes, Judge.
Right. With that clarification, Mr. Goldman, is that the correct statement of your client's agreement?
It's very close. Devin, did anything sound different enough that you wanted to talk about that with me in a separate room?
I don't think so.
Okay, that all sounded good?
Yeah.
It's good, Your Honor.
All right. Thank you, Mr. Goldman. Right. So Mr. and Mrs. Goins, can you both please raise your right hand to be sworn, please? Thank you. All right, Mr. Bruce, we're going to begin with Mr. Goins, please.
Yes, Mr. Goins, you recall coming to my office having a complaint for divorce filed in this case?
Yes,
And at that time, you had 3 minor children, correct? Timmy, Gabriella, and Harper.
yes,
And to your knowledge, your wife wasn't pregnant and is not currently pregnant, correct?
correct,
No other children adopted in or out of the marriage, correct?
correct,
And would you state that there's been a breakdown of the marriage, such that the objects of matrimony have been destroyed? There remains no reasonable likelihood that your marriage can be preserved.
correct.
And if the judge weren't to grant you a divorce today, you wouldn't reconcile and get back together with your wife, would you?
Can you repeat that? I misunderstood.
If the judge weren't to grant you a divorce, would you reconcile and get back together with Miss Goins?
No,
And you understand that in the judgment of divorce, you're not being awarded any spousal support, correct?
yes,
And you understand you can't come back, ask for it at a later date, right?
correct,
And you believe the judgment's in your kid's best interest?
yes,
And you're asking the court to enter that today, correct?
correct.
Nothing further, Judge.
Thank you, Mr. Bruce. Mr. Goldman, do you have any questions, first of all, for Mr. Goins?
No, Your Honor.
Questions for Ms. Goins, please?
Yes, thank you. Devin, please state your full name for the record.
Devin Marie Goins.
And did you hear the questions that Mr. Bruce asked Mr. Goins?
Yes.
Were those answers accurate as far as you know?
Yes.
Is there any possibility that you may be pregnant today?
No.
Do you understand the terms of the agreement that we discussed in mediation today?
Yes.
Do you have any questions about that agreement?
No.
Do you think that agreement is in the best interest of your children?
Yes.
And do you believe that regarding the property division, that is fair and equitable?
Yes.
Do you understand that property division is final?
Yes.
And do you understand that you have a right to trial on these issues?
Yes.
And that if you go to trial, the outcome could be better, could be worse, it could be about the same?
Yes.
And that by reaching this agreement today and having the court approve it, you're giving up your right to trial on those issues?
Yes.
And you agree that you'd like the right to change your last name back to Reidner if you so choose?
Yes.
Are you asking that the court waive the 6-month waiting period and approve this divorce today?
Yes.
No further questions, Your Honor.
Thank you, Mr. Goldman. Mr. Bruce, do you have any questions of Ms. Goins?
No, Judge, thank you.
And you'll prepare the judgment, Mr. Bruce?
I will. I think the 6 months.
The 6 month statutory waiting period will expire on September 19th, Mr. Goldman, so it's right around the corner. So that will we'll be very close to that by the time the judgment is submitted. I'm sorry, you had another question, Mr. Goldman?
No, Your Honor.
Right. All right, the court would like to thank and acknowledge Mr. Walker for his fine assistance in helping facilitate agreement between the parties. Also, the court would like to thank and acknowledge attorneys Goldman and Bruce for their assistance. The court would applaud you, Mr. Goins, for each your own agreements. One, if you can co-parent your children. You need to, even though you'll be divorced, you're still going to be tied together for life because of the children. So make it good for each other and the children. Based, however, on the testimony that's been presented, as well as the plain file in this case, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the consent judgment, the court will approve and enter that judgment. And at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. Good luck to both of you, Mr. and Mrs. Goins. That will conclude this hearing. You can all zoom out. Thank you again, Mr. Goldman and Ms. Bruce.
Thank you,
Mr. Walker. Welcome. For the record, this matter is before the court for a pretrial conference. Subsequent parties have engaged in mediation with Mr. Walker from the front of the court this afternoon. This hearing is being conducted via Zoom. Mr. Work is Mr. Petrangelo present?
I believe he was present in mediation, Your Honor.
Right, we call this prematurely. All right, we'll wait for Attorney Petrangelo. Is Erin Brown present in your office, or is she present in audio?
She's present by telephone, Your Honor.
Okay, Ms. Brown, can you hear the court?
I can, thank you.
All right, thank you. Just hold on. We'll wait for Mr. Petrangelo to zoom in. Mr. Petrangelo.
Good afternoon, Your Honor.
We've called the case and didn't realize we were missing you, so we waited for you. But in any event, this matter is before the court for pretrial after the parties engaged in mediation with Mr. Walker. The court has been informed the parties have reached their own agreement. Is that correct, Ms. Worka, Mr. Petrangelo?
Yes, Your Honor.
Yes, Your Honor.
Wonderful. Who would like to place the agreement on the record?
I will, Your Honor.
Please, Worker.
Thank you, Judge. The parties own 2 parcels of real estate. Ms. Brown is awarded the home located in Galt, California. Mr. Brown is awarded the home located here in Monroe. Each will pay all of the expenses associated with those homes, with the exception of until January 1st of 2025, Mr. Brown will continue to pay the home equity loan and the electricity for the home in California. And he also will continue to pay a cell phone bill that Ms. Brown's daughters are on currently. After January 1st of 2025, each party will be responsible for all of the costs of ownership for those parcels of property, and will take steps to refinance them to remove the others' names from the respective liens. For the retirement accounts, Ms. Brown is awarded a lump sum of $300,000 from Mr. Brown's DTE Energy 401k. Mr. Brown also has a lump sum pension that he will be converting to an annuity, and Ms. Brown will be listed as a surviving spouse for that annuity. Ms. Brown has an IRA. She is awarded that IRA free and clear of any claims of Mr. Brown. The parties agree to use Ms. Ann Pastrana for any quadro that may be necessary and agree to split the costs equally. They each will be keeping their own bank accounts. The joint accounts at Lake Trust Credit Union are awarded to Mr. Brown. The joint accounts at U.S. Bank are awarded to Ms. Brown, and the parties will cooperate to remove one another from those accounts. They are each keeping any debts that are in their own name. Plaintiff's name will be removed from the Lowe's credit card and the Sam's Club credit card. If that's not possible, both of those accounts will be closed. Ms. Brown is awarded the Toyota Highlander. Mr. Brown is awarded the Silverado, together with the lien on that vehicle. Mr. Brown is also awarded 3 Harley-Davidson motorcycles, a 1986, a 2003, and a 2008, as well as a 2009 Yamaha dirt bike. Spousal support is forever barred as to both parties, and any life insurance policies that the parties may have, they will be keeping their own. And I believe that is the entirety of the agreement.
Thank you, Ms. Worka. Mr. Petrangelo, did Ms. Worka accurately state your client's agreement?
As to those things, we agree. Just a couple other points. The cell phone bills that my client's paying for Ms. Brown's daughters, his obligation there will end at the end of the year. So he's paying those until January 1. We didn't mention it because they've been divided or living apart for quite some time, but I suppose we'd have in there that they will keep their personal property as otherwise divided. It's my understanding Ms. Brown is also elected to retain her married name.
Thank you. Ms. Worka, is that all correct and accurate?
Yes, Your Honor.
All right. Mr. and Mrs. Brown, can you both please raise your right hand to be sworn, please? Ms. Worka, you can begin with Ms. Brown, please.
Your Honor. Ms. Brown, can you state your full name for the record?
It's Erin Lori Brown.
Okay, and you currently reside in the county of Monroe, state of Michigan?
I do.
And did you live in the state of Michigan for 6 months before you filed your complaint for divorce?
I did.
And did you live in the county of Monroe for at least 10 days before you filed?
I did.
Okay, and were the allegations true in the complaint for divorce that you filed?
They were.
And are they still true today?
They are.
Okay, are you currently pregnant?
No, I am not.
And has there been a breakdown of the marriage such that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
That is true.
Okay. And you heard the terms of the settlement agreement that I just placed onto the record a few moments ago?
I did.
And you agreed to those terms?
I do.
And you understand them?
I do.
And you agree to be bound by them?
I do.
And do you understand that the property settlement cannot be changed?
I do.
And do you understand that by entering into this agreement today that you're waiving the right to go to trial and that you could have done better, worse, or about the same if you had gone to trial?
I do.
Okay. And are you entering this agreement of your own free will?
I am.
And are you satisfied with my representation?
I am.
Okay. Thank you, Your Honor. I don't have anything further.
Thank you, Ms. Worka. Ms. Brown, were there any children born of the marriage or are still minors?
No, we do not have any children together.
Okay, thank you. Mr. Petrangelo, do you have any questions of Ms. Brown?
Ms. Brown, did you disclose your assets and liabilities as part of these negotiations?
I did.
You didn't hide anything, did you?
No, I did not.
Okay, and do you also understand that the provision regarding spousal support or alimony, and this will apply to both of you, it's forever barred. Nobody can come back on that, as well as the property settlement. Do you understand that?
I understand that.
Okay. I have no further questions, Your Honor.
Thank you. Mr. Petrangelo, questions for Mr. Brown, please.
Yes, Your Honor. Thank you. Mr. Brown, did you hear the settlement placed on the record today?
Yes.
Do you understand it?
Yes.
Do you agree to the terms that were placed on the record?
I do.
Do you also understand that you could have gone to trial and you might have done better than this at that trial, or worse, or the same, and you are giving up your right to that trial? Do you understand?
Yes, I do.
Have you had enough time to think about this?
Yes.
Have you fully disclosed your assets and liabilities to the best of your knowledge?
I have, yes.
Sir, men can receive spousal support, and you are forever giving up your right to make a claim for spousal support. Do you understand and agree to that?
Yes, I do.
And as well, the property settlement, you'll be bound by this. You can't change your mind tomorrow or anything else. This is it. You understand? What was that? I couldn't hear you.
I understand, yes. Mm-hmm.
Are you satisfied with my services as your attorney?
Yes.
Your Honor, I have no further questions.
Thank you, Mr. Petrangelo. Ms. Worka, do you have any questions of Mr. Brown?
No, thank you, Your Honor.
You'll prepare the judgment, Ms. Worka?
Yes, Your Honor.
Very well, the court would like to thank and acknowledge Mr. Walker for his fine assistance this afternoon in helping facilitate amicable resolution, as well as attorneys Worka and Petrangelo. And the court would applaud you, Mr. Brown, for reaching your own agreement. Without question, the best resolution of matters of this nature are one which you both participate and ultimately agree upon. Far better off to have the court make these decisions. Keep in mind, you will not be divorced until the court signs written judgment. Based, however, on the testimony that's been presented this afternoon, as well as the complaint filed this case, court finds that jurisdiction has been established. The court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed. There is no reasonable likelihood that the marriage can be preserved. Or accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce from bonds of matrimony. That will conclude this hearing. Thank you again, Mr. Petrangelo and Ms. Worka. That will everyone can zoom out and have a good rest of the day. Good luck to you, Mr. Brown.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Request of Anthony Zjack. This hearing is being conducted via Zoom. Katie Neal is present. You are Katie Neal, is that correct, ma'am?
Yes, that's correct.
Okay. Is Anthony Zjack present on the audio?
Yes, sir.
Good afternoon. Also, with court note for the record, Attorney Stephen Rodenberg is present, representing the petitioner, Anthony Zjack. So Mr. Rodenberg is personally present in court this afternoon, Mr. Zjack.
Yes, sir.
Before we begin, the two of you are not married, but you have a child in common. Is that correct?
That's
yes,
correct.
sir. And a home in common.
Okay, and the court would note this is with court considers to be a bare bone to PPO. Bare bone PPO. All it prevents you from, Ms. Neal, is from assaulting Anthony. That's illegal anyways. Prevents you from threatening him. That's illegal anyways. Threatening to injure or kill him. And finally, it says all communication shall be by text message or by app close regarding your child only. Doesn't prevent you from having dinner together, sleeping together. So you got to the burden to prove to this court that this PPO should be set aside. You suggested you've only had a few phone calls to talk to your son. Obviously, file a motion in the family court case if you want more parenting time, or if there's issues. That can be better addressed in the parenting time case, not this PPO.
All right, yes, I have went ahead and filed motions a couple times for that, but nothing's getting resolved. We actually had a hearing the 3rd for that. And I understand completely about app close, but I would like to state that I filed this motion for the PPO because we're just here. I think it was February. I've had 3 PPOs on Anthony, which each time he's came in contact with me, talking me into dropping these PPOs. And I feel like if he felt that I was a threat to him, he wouldn't have had me originally drop the PPO I had on him. But as well, I was only contacting him on a private number because since January 19th, 2024 at 12:21 a.m. until June 16th, he did not have app close, and I turned in screenshots to back that up because it shows the last time he was on app close and all those days I was messaging him. And when I did call him, it was regarding to talk to my son. I never threatened to harm him. I never assaulted him. I feel like if he was
does not matter, ma'am. This court just said all communication should be by app close. The two of you maybe should not have had a child together, but the reality is you did. So all communication, no phone calls by either one of you. You do it by app close, so it's all reduced to writing, and it should be regarding your child. It shouldn't be how's your day today. Should be only regarding the child.
I understand that, but how do I do that if he's not active for 6 months? How do I get in contact with him?
Okay,
6 months I've
Mr. Zjack, you need to download the app called App Close, and all communication regarding App Close. If Miss Neal files a motion in the family case, I'm going to order that. I'm telling you that right now. The only case for the court this afternoon is this PPO file, but that's what the court would order. So the two of you should communicate. Yeah, you have to communicate. You've got a child to get in common. What if there's an emergency? But all communication, and if you need to modify parenting time, but it shall be by app close. So it's all reduced to writing. We can get records of all your communication rather than calling each other. And that when you call each other, that just results in arguments and it creates more issues. You understand, Mr. Zjack?
Yes, sir.
Go to the App Store and download the App Close.
Sir, I've been using it for since what she's talking about the time we were basically together at the time, and I'm there every day. So she's telling me that I'm not using the app.
Just hold on. I don't know what the breakdown is. You're both on App Close. Well, I don't know where the breakdown of communication is. Miss Neely says he's been on App Close. So Mr. Neely, Mr. Zjack, you need to respond when she communicates with you.
I go days without talking to my son, anything about my son, as a mother, that hurts me, and I can only imagine it hurts my son. They try to say I'm mentally unstable. Well, I'm sorry, maybe I am going a little crazy when I'm going days at a time without my son knowing anything. Like, my son's my life, and I'm like, he's not responding to me for like a punishment because I don't want to be with him.
Okay, Mr. Neal, I can show you. Hold on. The thing before the court today is a PPO, and the court's going to deny the request to terminate the PPO. The two of you need to have some structure. It's a very limited. If you want to address family court case, you need to file a motion in the family court case, whether it's a DS or a DC or a DP case. File a motion there, and yes, the court would grant some of the relief. I can grant much broader relief in that case than I can as PPO.
Also, the PPO states I can't harass him, molest him, etc. Well, if he's feeling threatened for his life, why is he coming to my house telling me about his day, how he was injured, and wants me to nurture him and to love on him? And I have a hard drive right here. After he got this PPO, he came to my house. He laid next to me. He was filling up on me. He got unclothed and he was intimate with me. So if he's feeling this way towards me, why did he come to my residence?
The court does not disagree. The court does not disagree. Mr. Zjack, do you want to terminate this PPO? Do you agreeable with her the motion?
No, sir, I'm not agreeable with the motion.
Mr. Zjack, why would you then have contact with her and be intimate? You're using this as a sword. This is supposed to be a shield to protect you, Mr. Zjack. Do not have any such contact with Miss Neal. If you're fearful of your personal safety and well-being, you should not be having any such contact.
Yes, sir. That's the way I feel, but the way the personal protection order I got.
The point's been made, Mr. Zjack. I don't have a lot of time this afternoon. Do not have any contact with her if you want this PPO to remain in effect. And you're saying you're opposed to it being terminated.
Yes, and I would basically I would like the third party with her. She doesn't being giving me everything a runaround. She's giving
That's a
everything a
family
hard
court
time.
case.
She's lying to you
Addresses
right
the
now.
family court
So
case. The only thing we're talking about today is PPO.
I
And
am
you
not
indicated
lying.
you're here for your personal safety and well-being. The two of you are like fire and gasoline. So the court's going to deny the request to terminate PPO. It's going to continue. It's very limited. It's a bare bone PPO. It keeps both of you apart. So Mr. Zjack, do not be reaching out to Miss Neal and asking her for a date or to have dinner with you, because obviously you're fearful of your personal safety well-being. If either of you have any issues regarding parenting time communication, you file that in the family court case.
yes, sir.
Am I able to get
That's what I told her too on Sunday.
I don't want him coming to my residence and touching me, especially when I'm telling him no. So am I
If he
able
touches you, you call the police. It's an assault and battery. If he touches you without permission.
I have, and they don't do nothing, so I gave up on the police. I have a video. I have proof right here on this hard drive. Anthony naked, and I'm telling him no.
Miss
So
Neal,
I don't.
do not let him in your house. Miss Neal, don't let him in your house. It's real simple. Don't let him in your house.
He kicked in my door.
Called trespass. He should be prosecuted for trespass.
They're saying it's trespassing because he's on the lease. He kicked in my door and went to jail that day for assaulting me because that door came and hit me, and he's still coming to my house. This is why
Stop lying, Katie. Oh my God.
All right, Mr. Roldberg, just one moment, Miss Neal, Mr. Zjack. Of course, give Mr. Roldberg an opportunity to talk. Mr. Roldberg.
Yes, sir. I can't hear nothing. You still there?
They put us in a different room. Just shush.
Oh.
All right, you're welcome. So, Ms. Neal, if there's any issues, for example, file a motion, the court will, without question, I will guarantee you, I'll order parenting time exchange to occur at the sheriff's department or the Bedford substation, the Dundee Police Department, whatever is easiest for you. So he has no reason to come to your house. If he comes to your house, he's trespassing. He should be arrested. Mr. Zjack, do not go over to your house.
The system's failing me. That's all I gotta say.
They really are.
Tell him, Katie. Tell him, Katie. That's my house.
Zjack, do not interrupt, Mr. Zjack. Do not interrupt. Miss Neal is talking.
Yes, sir.
When something happens to me, I'm telling you, Monroe County is going to be held accountable. I've had 3 PPO on this man in the past. He keeps coming back into my life. This is getting reversed on me. He's a narcissist. He love bombs me, then gaslights me. Then we have that trauma bond. Then he love bombs me and gaslights me. And everyone's saying that I'm mentally unstable, but it's because I'm abused. I'm abused emotionally, verbally, physically, mentally, sexually. And this is what no one's understanding.
Miss Neal, do not let him in your house. If he comes to your house, you call the police. What happened to the Miss Neal? What happened to the PPO? You claim you had a PPO. Is that PPO still in a place that you secured? What happened to the PPO that you obtained?
That PPO what?
What happened to the PPO that you obtained?
It's on me at all times.
No, I thought you said you obtained a PPO against Mr. Zjack. What happened to that?
He had girlfriends messaging me, sending me pictures of guns, threatening
Miss
to kill
Neal,
me.
Miss Neal.
He got in contact with
Answer the question.
me.
All right, we're done. All right, you can both zoom out. The court's denying the motion to terminate the PPO.
Just like
the court's not
after
going to
the
argue with the
top
parties,
court
and no one's
report
asking the court's question. You can terminate them, please. Court's had an order terminating, denying the motion terminated if you want a copy of it.